All right. We're at about 12:45, and we're going to get started again. And we are continuing with the hearing for Mr. Robert Moorman, ADC number 31293. And now we will hear from Pinell County. And sir, your name?
My name is Greg Bazazaro. I'm
okay.
the County Attorney at Pinell County Attorney's
All right,
Office.
thank you.
Chairman, members of the board, good afternoon. Council, good afternoon. My name is Greg Bazazaro, and I am here to speak on behalf of the Pinell County Attorney's Office, who back in 1984 prosecuted Robert Moorman. Because on January 13th of 1984, Robert Moorman murdered the only woman who we've heard who ever really loved him. On that day, he had received a compassionate leave furlough from the Department of Corrections, where he was serving a period of 9 years to life imprisonment for the kidnapping of a 9-year-old girl, or an 8-year-old girl, Shelley Mickelson. And as I think you saw in Exhibit 5 in the materials I submitted to you from Mr. Rex Gilliland, who is a distant family member of Roberta Maud Moorman, that Shelley Mickelson was a daughter of the family friend. He kidnapped her on January 25th, 1972, took her in his mother's car, and tried to take her to Las Vegas. And I will be addressing some additional facts that are particularly pertinent at a later moment when I discuss Mr. Moorman's intellectual capacity and his ability to not only plan but execute the murder of his mother. While he was serving that sentence, he was granted a 72-hour furlough. He was released to his mother's custody on January 12th. And they took up a room in the Blue Mist Motel, just literally across the street from the main complex of the Florence Penitentiary. It was later learned by law enforcement, and I think you have commented on it, about the codicil to his will that was located in the early morning hours of January 14th. That is Exhibit 1 in my materials that I submitted. And the thing that struck me, and I don't particularly want to date myself, but I was not practicing law when this all happened, is the fact that a document obviously drafted by Mr. Moorman, intended to be representing his mother's wishes, lists in there the transfer date being January 13th, 1984, not January 12th, not January 14th, but January 13th, the same day that he dissected his mother. In it, his mother purports to transfer to him what constituted, based on the testimony at trial, a large, if not the main portion of her estate at the time. Several parcels of land and property in Flagstaff, along with Indian jewelry and coin collections. Mrs. Moorman's estate was valued by her executor at about $308,000. And as I listed again, and as was presented in trial, Mr. Moorman was intended by Mrs. Moorman to inherit that property upon her death. But it was to be held in trust, because she did not trust him with the money. She wanted the executor to manage the estate, and he would live off the interest that those properties generated. And yet, before he left the prison, he drafted this codicil. As the records reflect, at about 6:30 to 7 o'clock in the morning, he went to the U Totem store, which is now a Circle K, I understand, in Florence, Arizona, and purchased the two knives, the folding hunting knife, the buck knife, and the steak knife. He then contacted the lady who had transported his mother down from Mesa after she'd gotten off the bus, and asked her if she could drive him to Mesa so that he could speak with a lawyer. A little later, he made contact with the manager of the motel. and asked that they suspend services to the room, that they not make up the bed, that they not replace the towels, that he would take care of that. And he also asked the woman, the wife of the motel owner, for some Lysol because his mother was ill. And she noted at that time that he smelled terrible, and she saw some blood on his face. By the time Mrs. Moorman's bag arrived, and if I digress, I apologize. I'm fairly new to this, so I'm still trying to keep the facts straight in my head. Ms. Southworth had to come down on the 13th because Ms. Moorman's bag had been left or lost by the bus company, and she had recovered it, and she was coming back down to drop it off. And she arrived sometime in the afternoon, and Mrs. Moorman was not around at that time. Later on in the day, he made requests of a pizza parlor owner and I believe a liquor store owner if he could dispose of some spoiled meat in their dumpsters, and they refused. But they were suspicious, and they called the Florence Police Department. At about 6 p.m., the Florence Police Department came to make their first welfare check. And at that point, he told the police that his mother was off visiting a Mexican lady who he didn't know. They didn't notice anything wrong. They did smell a strong sort of medicinal odor, and yes, Mr. Moorman appeared to be acting oddly. But when they spoke to the motel owner, he had a memory that he had seen Mrs. Moorman at about the same time. So they thought nothing of it. They checked the motel's dumpsters at that time and found nothing. We know from the record as well that in the early morning hours of January 14th, about 12:30 or so in the morning, Mr. Moorman contacts a Department of Corrections employee and informs him that he has come into possession of some spoiled dog bones that he can't get rid of at the motel because the dumpsters are full, and asks this Department of Corrections employee if he will dispose of the bones for him. For some reason, I don't know why somebody at 12:30 in the morning would be agreeing to collect dog bones, but he does. And he takes those bones and deposits them in the trash at the Department of Corrections. Once the Department of Corrections became aware that Mrs. Moorman was missing and there was some suspicion surrounding Mr. Moorman, those bones were collected and they were later identified as human bones. And I apologize for the rather graphic photos that are in my presentation, but I believe they are necessary to understand the degree of effort Mr. Moorman went into to not only plan this assault and this murder, but to try to get away with it afterwards. Mr. Moorman was eventually taken into custody by law enforcement at about 1:30 a.m. and literally sat in their car for about an hour and 45 minutes. And once law enforcement the Florence Police Department learned that the bones were in fact human, they placed him under arrest on suspicion of murder. And that's when he made his first statement to law enforcement where he said, "You can change the charge. She's dead." They subsequently, sometime around 3 o'clock in the morning, conducted a recorded interview with Mr. Moorman, some excerpts of which I have included in my presentation. And I would also note in the 2005 Ninth Circuit opinion in the appendix, there is an entire transcript of the recorded conversation that Mr. Moorman had with the Florence Police Department. He acknowledged at that point that he and his mother had been in an argument, that he'd struck her, and that he tied her up, and she kept on talking to him, and that he eventually smothered her with a pillow. He then says he transported her into the bathroom with the 409 and proceeded to dissect her. We know from the medical examiner's testimony that through the bruising and the cuts on Mrs. Moorman's breast and buttocks, that she received several injuries prior to her death. And that was the primary basis for the finding that the homicide was especially cruel because Mrs. Moorman was deemed to have been aware that she was about to die and suffered great mental duress as a result of that. Mrs. Moorman was 74 years old at the time that her son murdered her. He then took the knives that he had purchased from the U-Totem and proceeded to dissect her body in what the medical examiner described as a meticulous manner. He removed her head, legs, and arms from the torso. He cut the torso in half. There are additional photographs that indicate he attempted to quarter the torso. In a number of the materials, I saw that Mr. Moorman, before his father died, used to hunt and fish with his father regularly. So Mr. Moorman was no stranger to catching, killing, and cleaning animals. What I found most telling about his planning for disposal of the body is the statement he made to the Florence Police Department, where he says, "But then I decided at first I put the arms and legs into bags, and then later on I decided I knew if I could, it would be easier to dispose of her than I dissected her completely." So as he's making his decision to kill, he has a realization that he needs to be able to bring her out in small, portable, easily concealable packages, and he does that. He gets plastic bags from the grocery store, sometimes double bagging to make sure the bags wouldn't burst or leak. He removes the flesh from the bones, and he packages them up neatly and throws them in various dumpsters around the town of Florence. He also, again meticulously, as referred to by the medical examiner, removes her fingers, all 10 of them, and flushes them down the toilet. In fact, he tells the Florence Police Department that he flushed 9, but he couldn't find the last one. And he eventually found the last one around the room and flushed it. I submit that that was done in order to prevent identification of whatever remains were eventually discovered, because he did learn that the trash was not going to be picked up until that following Monday. Mr. Moorman exhibited a similar capacity to plan and execute violent, dangerous crimes in his earlier 1972 conviction. In that case in Flagstaff, he had rented a room at a local motel and acquired a .22 caliber pistol. He was evaluated at the Arizona State Hospital after he was arrested, and he told the doctor there that his original plan was to take the mother of Mrs. Mickelson, take Mrs. Mickelson, the mother of Shelley Mickelson, to that motel and rape her. But he lost his nerve. And then he saw Shelley walking on the road. He took her to the motel and at gunpoint forced her to perform sexual acts upon him. He then took her, planning to take her to Las Vegas. They spent the night at another motel. He got off the road, he got lost, I believe, and then the car wound up getting stuck in the mud on a dirt road, and they spent the night there. And he eventually carried her back, carried her back to the paved road, met up with a family who took him to Las Vegas, at which point he turned himself in to the Las Vegas Police Department. When Mr. Moorman was evaluated in 1972, he had an IQ test performed then, the WACE. He was 24 years old at the time, and at that point his full-scale IQ was 86. When Dr. Overbeck, the defense expert in his mother's murder, in the trial for the murder of his mother, evaluated him prior to the trial in 1985, his full-scale IQ at that point was, I believe, 96. Dr. Weinstein testifies nationwide in capital cases on this phenomenon of the retroactive mental retardation. And he has in the past, in his testimony, acknowledged that IQ examinations given closer to 18 years of age are sometimes more telling and more indicative of mental retardation than IQ examinations given much later in time, especially 28 years after the fact, and after Mr. Moorman has acknowledged suffered serious health issues, including a stroke. I included in my presentation as well two long excerpts from the most recent Ninth Circuit opinion from 2010, where they noted number one, the overwhelming evidence of premeditation that existed. In addition to the financial motive that they discuss, the fact that Mr. Moorman tied up his mother, the fact that he struck her and inflicted the lacerations on her prior to her death, all in their mind established sufficient time for Mr. Moorman to premeditate the act. Now, we do need to concede that at the time the definition of premeditation was different than the definition of premeditation is today. The definition of premeditation at the time allowed for premeditation to be found as quickly as successive thoughts of the mind. The current definition of premeditation requires a decision to kill followed by a period of reflection. In either case, there are sufficient facts to support the finding of premeditation that was found by the jury in this case. As Mr. Moorman informed the Florence Police Department, he tied his mother to the bed, he acquired the knives, he broke up the razor blades. The physical evidence from the autopsy revealed that he struck his mother on multiple occasions. As well, the financial motive. And as the other portion that I pointed out was that Mr. Moorman, at his trial in 1985, the jury heard and the judge heard a great deal of what was presented here to you today. A great deal of testimony was presented through Doctors Tuckler, Cleary, and Overbeck regarding Mr. Moorman's past developmental, psychological, physical history, including the allegations of abuse. All of that was available to the judge, and the trial judge, when he imposed the sentence of death, did find a single mitigating factor that Mr. Moorman's ability to perceive the nature of his actions was severely impaired by his mental defects. I should also point out to you, with regard to IQ, that Dr. Potts, who has testified to you today in his declaration from 1998, while he conducted no formal IQ testing, estimated that Mr. Moorman's IQ was somewhere between 70 and 90. And as Dr. Weinstein has pointed out, the cutoff for mental retardation in Arizona IQ-wise is 70. Ladies and gentlemen, the trial court found three aggravating factors to support the imposition of the sentence of death. The prior felony conviction resulting in life imprisonment, the especially cruel nature of the crime, and the crime was financially motivated. These aggravating factors have withstood 28 years of litigation in the appellate courts. We are asking, the Pinal County Attorney's Office is asking that you deny the request for clemency. As well, again, I refer you to Exhibit 5, the letter from Rex Gilliland, one of the last surviving members of Maud Moorman's family. He as well is asking that you deny the request for clemency. Thank you very much.
Thank you. Is there any questions of?
Oh, I'm sorry.
No, that's all right. I just want to see if there's any questions from board members.
Yeah, I just
Yes,
have
Mr.
one.
DeSoto.
Did Mr. Moorman testify at his trial?
I don't believe he did.
Is that right? You did not, okay.
All right, thank you, sir. Appreciate it. And now, if there's anyone from the audience that wishes to make some statements to the board, now would be your opportunity. If, sir, you can come up.
Mr. Belcher, members of the board, my name is Dan Peitzmeyer. I'm a 35-year resident of Arizona, and I'm concerned about some of the policies and practices of our state. As Dr. Conti stated in his video testimony, killing anyone is a primitive act. That's a direct quote from Dr. Conti. Killing anyone is a primitive act. I'm asking that you recommend our state not engage in this primitive act. There's been much testimony to Mr. Moorman's diminished capacity. In Arizona, we don't execute people with intellectual or developmental disabilities. We execute people who are the worst of the worst. I contend that Mr. Moorman's crime, hideous as it was, as described by Pinal County prosecutors, is not the worst of the worst. Frank Edward Lewis killed 2 men. He's serving a life sentence. Gary Dwayne Skaggs macheted 2 people to death. He's serving a double life sentence. David Brian Leggs, in what is obviously a premeditated murder, killed his parents, stole his mother's rings, and used the proceeds to go to Hawaii, a trip he had booked 2 weeks before the murders. Now, I don't know whether Mr. Moorman is capable of premeditated murder. I do know that capital punishment is the most premeditated of any murder. We will not be safer as a society if we execute Mr. Moorman. And I'm asking that you recommend the state not engage in premeditated murder. Please grant him clemency.
Thank you, sir. Is there anyone else wishing to address the board? All right, seeing none. Ms. Hall?
Just very briefly, Mr. Chairman, members of the board, the county attorney went through the facts that were the state's version of the facts at the trial, and argues that it shows premeditation. You have before you the declarations of 2 jurors who say they don't believe Mr. Moorman premeditated this crime. So the state wants you to believe the system worked in this case, and we think it's very clear that it didn't. They say that Mr. Moorman had an elaborate plan to get away with this crime, but yet at the same time they concede he was calling the prison to give them, to hand over the evidence to them in the case, to give them the bones. There was nothing sophisticated, there was nothing planned, and in any event, if you listen carefully to his presentation, the evidence he was relying on was almost entirely, the actions of Mr. Moorman he was relying on were almost entirely after the crime. And so therefore they were irrelevant to premeditation. I am begging each of you to give your strongest recommendation to the governor to show mercy on Mr. Moorman. Mercy isn't earned, it isn't deserved. It's granted in part because of who he is, but mostly because of who we are. I think you could tell he did his best today, and Robert, you had a lot of courage to come here and take responsibility for what you did. Have pity and allow this man to die a natural death in prison. Please recommend that the governor commute his sentence to life in prison. Thank you.
Thank you. See if there's any questions by board members of any of the witnesses. All right, hearing none, we are going to vote on 2 issues here today. One would be obviously the application for a commutation of sentence. The other is a matter of reprieve. And you didn't, are you requesting?
I apologize, I thought we would address that separately.
Well, we can. We can after we take this motion, then I'll give you the opportunity to speak on that if you wish to, as well as from the Pinell County Attorney's Office. So in a matter of a commutation of sentence, is there any board discussion regarding a commutation of sentence for Mr. Robert Moorman, ADC number 31293? Any board discussion? Hearing no board discussion, I'll entertain a motion regarding the application for a commutation of sentence for Mr. Moorman.
I move to recommend to the governor that she commute the sentence of Robert Moorman.
Mr. Lasota makes a motion to recommend to the governor a commutation of sentence and to
Life
what
imprisonment.
specifically?
Life imprisonment without the possibility of parole.
Life imprisonment. Do you, when you say without the possibility of parole, or is it better said without the possibility of release on any basis? Because if, you know, parole is one thing, but, and I'm not trying to structure.
No, that would be
Yeah.
my intention.
Yeah, I'm not trying to structure your motion, but that way there
A
would
true
be,
life sentence.
there
be
would be
substituted.
no commutation application, no pardon application, none of that would be available to him if it was
Yeah, I haven't.
life imprisonment without the possibility of release on any basis.
I haven't heard anything from the folks that have spoken in favor of Mr. Moorman, or Mr. Moorman himself, making any argument that he ever should be released.
Okay.
The
so
only
that-
argument is if he
okay.
hasn't, he shouldn't be executed. So I would fully agree with that, Mr. Belcher.
We have a motion on the floor. Is there a second to the motion? Mr. Lasota. Hearing no second, is there a counter motion?
I'll make a motion to not recommend to the governor any commutation
I'll second.
for Mr.
Ms.
Moorman.
Stinson makes a motion not to recommend.
I agree.
Commutation. And Mrs. Wilkins, you seconded?
Yes, I did.
And Ms. Kirschbaum agreed.
I disagree.
Okay. Mr. Lasota disagrees. I will agree. All right, and it's been, there was a motion that was entered by Mr. Lasota, which was not seconded. There was a counter motion to not recommend clemency to the governor on behalf of Mr. Moorman. That was seconded and voted upon. All board members agreed with the exception of Mr. Lasota, who disagreed. And now we will entertain the issue of a reprieve. If
Mr. Chairman, you heard the board heard Dr. Weinstein's testimony regarding mental retardation, and I think based on the county attorney's response, you can tell there are a number of contested issues regarding the law on mental retardation in Arizona, and those are currently being litigated in the state courts. 2 days ago, the Pinal County Superior Court, we moved under the state statute for a hearing to give us an opportunity to prove his mental retardation, which would then exempt him from the death penalty. 2 days ago, the Pinal County Superior Court denied the motion because it didn't have time to hold the hearing before the execution. And in Arizona, the board is probably familiar with this, the Superior Courts do not have the power to enter a stay of execution. And so at this point, we have a court that has indicated it would grant a hearing if it had time before the execution occurred, but it doesn't. We've appealed that decision to, not appealed, we've addressed that motion to the Arizona Supreme Court, asking them to issue a stay for the Pinal County Attorney's Office. But we would ask this board to recommend to the governor to give us that opportunity without waiting for a decision from the courts. And we would ask that the board recommend to the governor a 7-day reprieve. It would allow this warrant to expire so that we would have the opportunity to complete a full mental retardation evaluation, have a hearing before the Pinal County Superior Court to give us the opportunity to prove the legal basis for Mr. Moorman's exemption from the death penalty. Thank you.
All right, thank you. And let me just ask this question. The issue of mental retardation, how long has that been an issue? Obviously, the crime is a number of years, back in '86, and how long has that been an issue? And I guess I'm looking at it in a very simplistic way. Why has that not been addressed with the court recently, prior to the last month or 2 months or 3 months or 2 years or 3 years?
The most simplistic answer to that question is Arizona, as do many states, and it's based on the definitions of mental retardation, have a requirement that they have several separate requirements, as Dr. Weinstein explained. One is that there be an IQ 70 or below. Another is that the conditions that make up mental retardation onset before the age of 18. So in most cases, those two things coincide. You have a child who, and Mr. Moorman was very developmentally disabled from an early age. There are IQ scores, and granted that the history of his IQ scores is very confusing, and I think they've been misinterpreted, and there's a lot of data missing about them, and that's what the hearing would resolve. All of those questions would be resolved by the hearing. So what we have in this case is kind of a unique situation where I don't think there's any question. Onset of these conditions, you've heard, was from the time of birth. And so we've always met that requirement that onset was before the age of 18. But the second requirement that we had, the IQ score below 70, has been missing from the data until Dr. Weinstein's recent testing. And so the legal question that will be before the court, which has never been addressed before as far as I know, is when you have a case where basically two pieces of the puzzle existed before and then the third piece of the puzzle exists now, and it's extremely difficult, if not impossible, to say, given his disabilities at birth and through childhood, combined with his recent significant medical events that have been medically proven to affect IQ, exactly when did he reach that IQ score? Our position is that Mr. Moorman has always had mental retardation, but we never met the strict requirements of the law. And now he does, and now we would like an opportunity to prove that to the courts.
All right, thank you.
Thank you.
Yes, sir.
I think it was just a misstatement on Ms. Hall's part. I think she said at one point that the Pinal County Attorney's Office requested a stay or didn't have time to respond to the stay. We're not, involved in the litigation of this issue that has been presented. That's been being handled by the Attorney General's office. They have responded in opposition to the request for the stay. Their position is that the defense is not entitled to the relief that they are seeking, and that matter is currently pending before the Arizona Supreme Court. It's hard, I don't believe a reprieve should be granted when the fundamental basis for the reprieve is testing that was done within the past month or so on Mr. Moorman. When there was testimony at his trial, Dr. Overbeck testified most emphatically at the trial that he was not mentally retarded. And they are attempting to essentially relitigate this issue now, 28 years later. So I would oppose the request for reprieve.
All right, thank you, sir. And is there any board discussion regarding the matter of reprieve on Mr. Robert Moorman's case, ADC number 31293?
Well, Mr. Chairman, the board has spoken with regard to the fundamental issue here. And because this matter is in the courts and is, Ms. Hall, in what I thought was a very good explanation of why the delay, has said that it's, they've got an application for stay with the Arizona Supreme Court. I don't think there's any reason for us to grant a reprieve at this point, because I think if the courts feel that they need more time to consider that issue, they can well handle it. I mean, it's already there, so
They can issue a stay
I
order.
wouldn't personally be in favor of a reprieve, given that I was on the minority side on the fundamental issue, but the board has spoken, and the courts have this other issue, so I don't think it's appropriate for this board to be involved.
All right, thank you. Is there a motion regarding reprieve on behalf of Mr. Moorman?
Motion is not to recommend a reprieve.
I'll
Ms.
second.
Kirschbaum makes a motion
I second.
not to recommend to the governor, and that would be a reprieve, and Ms. Stinson seconds.
I agree.
Ms.
And I
Wilkins
agree.
agrees, Mr. Soda agrees, and I also agree. All right, it's been a unanimous decision regarding reprieve not to forward a recommendation for a temporary delay, i.e. a reprieve in this particular case. Thank you all for your time, your interest, and your cooperation here today. The hearing is now ended.